Okay, would like to call the meeting to order in accordance with the Open Public Meetings Act, PL 1975, Chapter 231, adequate notice of this regular meeting of the Board of Adjustment of the Township of Franklin has been provided. Would you call the roll, please?
Mr. Betterbid, he asked to be excused. Mrs. Gramman.
Here.
Mr. Johnson asked to be excused. Mr. McCracken. Mr. Rich.
Here.
Mr. Shepherd is traveling outside the country, so he asked to be Mr. Caldwell. Mr. Rosenthal.
Here.
Mr. Reese.
Here.
Mr. O'Connell asked to be excused this evening. Mr. Thomas.
Here. Okay, minutes of the regular meeting, October 17th, 2013. If there's no discussion, I'd like to have a motion
I move. Accept the minutes.
and a second.
I'll second. I'll second.
Ms. Graham,
Abstain.
you were there.
I don't think so.
You sure?
I looked on the, when I looked on, yeah, I
All right,
wasn't there.
she had you as there, so but that's okay.
Okay.
Mr. Rich,
Wasn't there.
Mr. Rosenthal,
Yes.
Mr. Reese,
Yes.
Chairman Thomas.
Yes. The calendar for 2014, any corrections or suggestions or motions?
So moved.
Is there a second?
I second.
Ms. Graham,
Yes?
Mr. Rich,
Yes.
Mr. Rosenthal,
Yes.
Mr. Reese,
Yes.
Chairman Thomas.
Yes. A voucher for Mr. Bradshaw, December retainer, 865.
Move it.
Is there a second?
Second. You can do that.
All in favor?
Aye.
Opposed? Motion passed. We are here tonight for an interpretation. Dunbar Homes, they're appealing the zoning officer's decision. So we can begin.
Good evening, Mr. Chairman, members of the board.
Hold the mic.
Make sure it's on first.
It says on, but it doesn't sound like it's doing it.
Try the other one.
How about that?
No, sir.
Maybe somebody can help them.
It's a double switch.
It's a double switch, maybe there.
Usually there's one on the bottom, I think, and one on the side.
Better?
Better.
There we go. Let's try again. Good evening again, Ron Shimanowitz from the firm of Hutton Shimanowitz for the applicant Dunbar Homes, Inc. Actually, a just real quick correction. We're actually here for an appeal of the zoning officer's decision, which is slightly different than an interpretation, but in sort of the same field. The appellant is Dunbar Homes, Inc., which is the owner of the subject property. The subject property that you'll be hearing about tonight is Block 85, Lot 59.04. It's commonly known as 1701 Route 27 South. It comprises about 6.93 acres, almost 7 acres. It's located in your GB, a general business zone. The site has an existing development on it. That existing development is approximately 48,378 square feet of retail space. 60% of that existing space is now vacant, so this is somewhat of a moribund development in need of some change. And I offer some of this as background. We do have two witnesses that will testify to much of this, but I just wanted to set the stage for the board in terms of what it is that we're asking for and what the issue is that the board needs to decide. The property, as I stated, fronts on Route 27. Adjacent to and immediately behind the subject property is the existing Hempstead Gardens apartment. Perhaps the board members are familiar with that complex. The retail center on the subject property and the Hempstead Gardens adjacent complex are two of several investments that the Dunbar, which is part of the Garden Homes company, have in the township. They've done quite a bit of work and development in the town of Franklin. For many years, and as of July 15th, 2013, the GB zone permitted as a conditional use garden apartments. On July 15th, 2013, Dunbar made applications to the zoning board for site plan approval and use variance approval. Those applications were for 55 garden apartments, including a 20% set-aside of affordable units, therefore proposing 44 market units and 11 affordable units for a total of 55 units. That application submission was a substantial package that was submitted to your planning department. There were engineering plans submitted, there were architectural plans submitted, many application documents with that submittal, of course, application forms and things like that. There was a estimated that the cost of that application process was about $40,000 in fees and other charges. A use variance was required as part of that application because the garden apartment conditional use in the GB zone includes a condition, or now included a condition, that the tract be a minimum of 10 acres, whereas the subject tract is approximately 7 acres in size, so hence the need for a use variance. On July 16th, 2013, a day after our application was submitted, the Township Council adopted Ordinance 4021-13, which became effective on August 5th, 2013, 20 days later. That ordinance eliminated the garden apartment use as a conditional use in the GB zone. On August 7th, a couple days after the effective date of the ordinance, your zoning officer, Mr. Dominack, sent me an email requesting 12 items needed for completeness of the application that Dunbar had submitted. That August 7th, 2013 Dominack email also took the position that Dunbar would require a D1 variance because garden apartments had been eliminated as a conditional use in the GB zone, whereas the applicant was pursuing a D3 variance pursuant to a conditional use. On August 16th, 2013, pursuant to Section 70A of the Land Use Law, Dunbar filed this appeal of the August 7th, 2013 decision made by Mr. Dominack, the zoning officer, and that's the appeal that you're considering tonight. Dunbar, the applicant or appellant, by tonight's appeal to the zoning board, is requesting that the zoning board reverse the zoning officer's August 7th, 2013 decision. Dunbar's appeal being considered by the board tonight is based upon a particular statute, and that is NJSA 40:55D-10.5, or what we refer to as Section 10.5 of the Municipal Land Use Law. That section is commonly referred to as the time of application law. Since the time of application law is central to the board's deliberations tonight, it warrants a recitation. The time of application law, Section 10.5 of the MLUL, states the following, and I quote, "Notwithstanding any provision of law to the contrary, those development regulations which are in effect on the date of submission of an application for development shall govern the review of that application for development and any decision made with regard to that application for development. any provision of an ordinance, except those relating to health and public safety, that are adopted subsequent to the date of submission of an application for development shall not be applicable to that application for development, close quote. That's the section of the land use law that is applicable to the issue before you. Your zoning officer, Mr. Dominack, by his August 7th, 2013 email to me, decided that the time of application law requires an application for development which has been deemed complete. Whereas Dunbar, the applicant, or our case tonight, we're looking, let me say it this way. The case we'll put before you tonight will establish that the time of application law, this section of the statute I just read to you, requires the submission of an application, but not an application which has been deemed complete. And we'll present evidence and testimony and opinion as to that conclusion. So as lawyers say, the issue is joined. We have a disagreement. Mr. Dominack's decision and position is that the applicant is only protected from a zone change if the applicant has submitted a application which has been deemed complete, and the applicant's position is that the statute doesn't say that and does not intend that, and it's just the statute requires that an application be submitted. We're asking that the zoning board reverse the zoning officer's decision and determine that the time of application law is applicable to Dunbar's July 15th, 2013 application for development, and therefore that the zoning regulations in effect on July 15th, 2013 govern Dunbar's application for site plan and use variance. So that, by way of background, is where we're at today. That's the issue that this board is to consider. We have received Mr. Dominack's memos on this matter. I think he wrote 2 memos. We're aware of those. And with that introduction and the chair's permission, I'd like to call our first witness, who
Well,
was...
before you do that,
Yes.
since you were giving a legal exposition of what your position was,
Yes.
did Mr. Dominack tell you upon what he based his conclusions on, why he was insisting that the application be deemed complete?
Other than that was his interpretation of the statute, but beyond that, he did not.
So, did you look at the municipality's ordinance and its definition of application?
Mr. Dominack actually provided us with a copy of, when you say definition of application, I'm
Yeah.
not sure what you referred to.
Application for development.
I've read the definition of application for development in the municipal land use law, and I've read the definition of application for development in your ordinance.
Okay, and our ordinance, at least as I read it, and I read your stuff very carefully,
Yes.
it says that an application for development in Franklin Township is an application that must be deemed complete. Isn't that what our ordinance says?
Your ordinance speaks for itself. I don't want to characterize it. It is different language than that which is in the land use law.
Okay.
So I don't know how to answer your question
Okay,
other than that.
And, well, okay, here's my problem with all of this, and it may cut things short or it may not. I'm bound by the language of the ordinance as a member of the board to make a determination that the ordinance is invalid, and it may be, I don't know. I mean, I suspect that the case law has not addressed that issue, but in any event, it's above my pay grade. I think that we just don't have, assuming that the basis upon which Mr. Dominack made that decision was not just, gee, I want it to be deemed complete, but my ordinance requires that an application for development be, in order to be deemed an application for development, be deemed complete. And I don't think, if that's the case, that he had any choice but to make the determination good, bad, or indifferent. And I, as I said, I didn't see the application, I don't address the merits of it. But I'm just wondering legally whether he or we have, if that's the basis upon his determination, whether any of us has the legal authority to apply the ordinance, go against the ordinance, or say, no, the ordinance really should adopt the MLUL definition, which does not include be deemed complete.
Yeah,
And
it's
that's my question.
Yeah, and it's a very fair question, and it will be part of the testimony we'll put forth. We do have a position on that, and we have an expert witness that will testify to that issue. The short version is that the MLUL definition of application for development controls, and the township does not have the authority to alter that definition. And we'll put forth a
Which
case law.
definition is that?
The definition of the phrase application for development, which is defined in the land use law, it is defined differently in your ordinance.
Okay, so, just so we're clear, starting with the first step, even if you take that as being true, which I completely disagree with, but if you take that as being true, and I'll take issue with your expert on that, but doesn't even that say that it has to be application form and all accompanying documents required by ordinance? Doesn't even that definition say you have to have stuff basically in accordance with our checklist?
Mr. Bradshaw, it certainly says what it says, and I won't argue about the
Well,
words.
you're here to argue.
Let-
You're here to make your case, and I asked you a
Well,
question.
if you let me finish, I'll be happy to make
Okay,
that
but I'm not
case.
going to let you dodge it.
I'm not planning to dodge it,
Okay.
just if you allow me to
Oh.
finish without interruption.
Sure.
And also, if you allow us to present our case, because we do have an expert on this issue.
But you
But
made
let-
opening
let-
arguments.
And let me, I'll finish my statement.
Okay.
The provision that you just read does not reference a complete application. There is another section of the land use law that references the completeness process, and we make a legal distinction between an application and a complete application. And what needs to be determined is whether Section 10.5 required a complete application or an application for development. And we will present testimony on that issue as to what was intended by the statute.
Is it fair to say then that your expert is going to tell us that he utilized the definition contained in 55D3 for application for development in his analysis, and not the one contained in our ordinance?
Yes,
Okay.
that's correct.
That is correct. And because I read his report and I read his question presented, and that's what it said. Do you not agree that Mr. Dominic was required to use the definition in our ordinance?
I do not agree.
You think he had the ability to disregard the legislative creation of this and look at his own definition, or look at the
Look-
MLUL definition?
Yes, we think that the ordinance definition of application for development is ultra vires, and the municipal land use law supersedes that definition.
Okay. And so then, if you follow that, you're also then asking this board to not follow the definition contained in our ordinance, right?
I would ask this board to acknowledge, based on the case we're going to present, that the MLUL is the law of the land as to that definition.
Okay. So you're asking them then to say, to make a finding that this definition doesn't apply?
Correct, that it's been superseded by state statute.
Okay. And would you say that that's a legal determination?
I would think so,
Okay.
yes, yeah.
I would say it's a
Yeah.
complete legal determination.
Yes.
Okay. Now, you've come in here on your letter under a certain statute that we both know the board has the ability to hear the powers of the board, and it's A, right? That was in your
Correct.
letter, 70A.
Correct.
Right. 70A, hear and decide appeals where it is alleged by the applicant that there is error in any order, requirement, decision, or refusal made by an administrative officer based on or made in the enforcement of the zoning ordinance. I mean, that's what it says. That's the horse's mouth right there, right?
You read it?
I read it.
Question your
Okay.
ability to read.
Where in that does it give this board the authority to disregard that ordinance, to make a determination, to make a legal determination that that ordinance is invalid? Show me anywhere that this board has the power to say that this is either unconstitutional, invalid, or anything. Show me any case law that says this board can make its own determination that its own township's ordinance is invalid, that we have some kind of legislative power to do that. Because absent that, I don't know how you can possibly make the arguments that you make. I need you to get over that threshold question for me, because I can tell you what I think ultraviolet virus is this board saying that this ordinance doesn't apply, that this definition, to be more specific, doesn't apply.
Well, I would say it's all wrapped into one. If Mr. Damanek made his decision based upon the definition in the ordinance of application for development, you can't get around the issue of whether or not that section of the ordinance is legal or not legal. It's all part of his decision.
No question about it. And I will tell you, and he'll tell you, and he's been sworn in, we swear him in at the beginning of every year, and we'll swear him in because he'll provide testimony tonight, but
Yes.
I will tell you that he's going to say that that's the definition he used. Now, if we're
And
all on the same
that's
page
fine.
that he used it,
Yes.
you're essentially asking us, not essentially, you're directly asking this board to say that that statute is, you come up with the word, irrelevant, improper, illegal, unconstitutional. And I'm telling you, I see no authority, certainly not under 70A, to allow the board to do it. I've never seen a case law that says a zoning board has the ability to kick out any provision of its ordinance. In fact, I've argued cases where the court has said that provisions of the ordinance are unconstitutional, but yet the board had to follow them because the board has no other power otherwise. And has affirmed the board for doing so.
Yeah, and perhaps it's a catch-22. A decision was made by Mr. Dominack. The only way I could challenge that decision is under 70A. That's very clear in the law. It's a decision
Well,
of the zoning officer.
To this board.
To this board.
Right.
That's correct. Now, I suppose, and I still have the right to do it, I could
You do.
challenge the validity of the definition of application for development, and maybe that will come to pass too. But this board is duty-bound to hear our presentation and our appeal. The board doesn't have to agree with our position, but you're duty-bound to hear it and make your decision as you see fit. And whether, I don't know where that ends up, if you don't agree with our position, then, it's likely we'll end up before the judge in the black robe, and perhaps that will be combined with a challenge to the definition of the ordinance.
Right, which would certainly include the township. It's not our ordinance, it's the township's ordinance. They would have to come in and defend it.
Without question.
The reason I ask this is because you certainly have the right to make your presentation.
Yes.
I just fundamentally, at the gates of this presentation, wanted to know to clarify what it is you're looking for this board to do, and to let you know, because if you had something, I was going to spend the time during your presentation trying to research. I just don't see any power that this board has that say that any provision of this ordinance should be eliminated. And since we both concede, I think, that Mr. Dominic used that definition to determine whether or not your client was complete in its application, I didn't know how you sidestep that.
Right. Well, I answered your question quite frankly that our presentation relies mostly and largely on the definition in the land use law. I would reserve my client's position with regard to how this appeal should be decided based upon the definition in your ordinance.
Okay.
So I would plead it in the alternative. So I understand your point, Mr. Bradshaw, but the only thing I could do in response to Mr. Domenech's decision, the decision of a
I'm not
zoning officer.
criticizing you, Counselor.
No, I don't take
know
it-
you're taking
yeah, I don't take it
proper
personally.
steps.
Yeah.
I wasn't sure if I was missing something. I don't mean to, you
I don't
have
think
your
you're missing
people here,
anything.
and I want you to, but I just wanted to make sure that, because I ultimately have to counsel them as to whether or not I think that they can make the determination you're asking them to make, one way or the other, yes or no, up or down.
Well,
But-
I'm kind of glad you raised the issue, because maybe the advice you can give the board, and I'm certainly not telling you how to do your business, but one
I
idea.
give it openly, so I don't have any.
We do the same type of job. One idea might be that, looking forward to the way this may play out procedurally, if we're not successful before the board tonight and we end up before the court, maybe the board should consider the issue both ways. Maybe the board should say, gee, how would we decide this if ultimately our ordinance section is not valid? And how do we decide this if our ordinance section is valid? And that's in response to the procedural issue that you
Why would we
raised.
do that?
Because Mr. Bradshaw raised the issue, and why waste time?
Well, we can get to that.
All
I mean,
Yeah.
Okay.
Fair enough. Again, as I started to say, and I'm glad we had that colloquy, Mr. Chairman, my first witness is Mr. Chadwick, with your permission.
And, Mr. Chairman, just for the record, Mr. McCracken arrived at 7:46, and since no testimony has been given, he is eligible to vote.
You know how to turn the second mic on, John? You got to talk into the mic, Joe.
Oh.
Oh, hello, Chairman.
So I have a question to you. This is, if it's above Laura's pay grade, it's definitely above mine, because at least she has legal education. So in my simpleness mind, why do we even have to go through a hearing? Because basically they're claiming that the township law was passed after their application was presented. Is that the crux of this whole thing?
Yeah, well,
Real simple?
well, I was talking about something different than the development law. Let's clear that up. The development ordinance meaning was eliminated the town homes, okay? That's different than application for development, which is a definition used to see if they've completed the application in a complete enough way to actually count, if you're putting it on the timeline. I mean, I think relevant to
So we're not discussing the timeline right now?
well, you may, but not just yet. My argument, or my point to council was, if he's basing his July 16th timeline that he says he handed in his application, it's Vince's position that what he handed in was not sufficient to count.
Okay, it wasn't complete enough.
And in that, there are definitions to determine, and that's ultimately the king
Well,
of the dispute.
also, I mean, just to clarify, what I was arguing was our definition of application for development, and you heard council read that section of the statute that talked about the time of application. The township's definition of application for development is a little stricter than the statute, the MLUL definition. It requires that the application be deemed complete And that was apparently not the case. It was apparently not deemed complete, and therefore the time didn't run. And that was the ordinance that we were talking about in terms of whether the board has the legal authority to overturn it or not.
Okay, so the applicant's counsel, or whatever you call them at this point,
Counsel.
Yeah.
is that the correct term?
Yeah.
Yeah, sure.
Okay.
Attorney, counsel.
Is claiming that our zoning board officer doesn't have the right to claim that application wasn't complete,
Was not complete.
was not complete.
Yeah, he's saying he was wrong. And I think he's saying, but we'll let him say it when he puts his,
Actually, I'd like to clarify that. I don't challenge Mr. Domenak's authority and role in deeming applications complete. That's part of what he does. The issue that we're raising is whether or not a complete application was necessary to come within section 10 point.
5.
10.5, I lost the section in my mind for a second.
There's a lot.
To come within section 10.5 of the land use law. So the question I raised in my introduction is whether or not the submission we made is an application for development which vests certain rights for the applicant under the zoning in effect at the time of the application. Certainly, Mr. Domenak has the authority to review applications and deem them complete. That's part of what he does as the zoning officer.
All right, so I have one more technical question. So is it really true that the town's law or definition of the application process, does that conflict with the state's with the state's law or application process?
Yes.
And does that tend to put our local ordinance illegal? I'm trying to understand.
Well, you're trying to understand it before we've discussed it.
Okay,
Okay, so, I mean, our position is no, and I think their position is yes, but
okay, I'll leave it.
you're trying to get the answer before you read the book.
I'm just trying to understand this a little better.
And let me just,
Well, this may be-
3 seconds before you, we're talking a lot of semantics, and Laura pointed out that our definition goes a little bit further. It's not more restrictive or less restricted, it clarifies what the MLUL says, is what it does. It gives, the MLU says that you have to submit everything to be an application for development as per our ordinance. So, and I think being complete means that you've submitted everything in accordance with our ordinance. We're not using the old verbiage that is in the report that complete is something different than the application for development. So my position, and then we'll talk about it later, is that there really isn't any big difference between the MLUL definition and the definition we have. We just clarify it and make it extremely clear what needs to be submitted to be an application for development.
Aren't you also saying, and tell me, of course, if I'm wrong, that our ordinance says it doesn't rise to the level of an application for development until it's complete?
Well, and I think we're getting caught, yes,
And then therefore...
it does, but we're getting caught on the verb.
Application for development coming from Franklin Township fits in with the municipal land use definition. It just says an application for development.
Yeah,
We're classifying an application for development after it's deemed complete. It's not an application for development.
it can't be deemed complete unless it meets the definition. And if it doesn't meet the definition, it's not complete, no matter how you,
Well, you're talking about the definition,
of application for
meaning it
development.
has all the required submissions.
We have, and when I give testimony later, you'll see that we have ordinances that spell out, and that are in our checklist verbatim, the different items that need to be submitted for every application. The definition says you must submit them to be an application for development. and you'll see later that they didn't submit a number of those, hence they didn't meet the definition of application, hence they didn't submit one, hence they are not complete. Whether you say they didn't meet the definition, or they weren't complete, or they didn't have enough, they didn't meet the definition, they aren't complete. So
These requirements are not in the municipal land use.
the,
in order to be
the
all-
requirements that they must submit are in our ordinance, as the MLUL, and our ordinance states that they must be.
I think you got a long, tough, steep hill to climb to convince me of anything. I don't understand. I guess we have to hear it because it enables you to get a decision and go to the next level. It's too bad, maybe it's too bad we can't shortcut that a little bit, but this board's consistently followed that guideline. There have been other more minor issues with, whether an application is completed or not completed. I mean, the deadline for action doesn't start until it's deemed complete, correct?
That's true.
Well,
So-
there's actually, that's interesting, because I may deem something complete at, let's say, October 1st, but if that and in this case, if that application had been submitted 3 weeks earlier, that actually would have been the date that an application for development was submitted. So we're talking two different things.
And if-
If they submit something and it takes me the 45 days to review it, and they had submitted it 45 days prior, the date that that application was submitted would be that original date. It just took me that date. The day the time frame would start, I believe, would be for our time to be able to do it, would be after that, the day I deemed it complete. But they're two separate things. That's where we're getting caught a little bit on the verbiage. Once they submit something that's complete, no matter how long it takes me in the time, what we're talking in this context, if they had submitted everything on that July 15th date that was in our ordinance, as per our checklist, and it took me, even after the date that the ordinance was ineffective, they would be entitled to go by the old ordinance.
Well, let's
But that's
hear
not
their
the case here.
testimony at this point. We're waltzing this thing around, and they need to make their case.
Go ahead.
John, if you raise your right hand, solemnly swear or affirm to tell the whole truth, nothing but the truth,
Yes.
and your name for the record. even though-
John Chadwick.
Okay.
This one?
We accept him as an
Yeah,
expert
you're good.
witness as long as
I'm a
he's...
licensed planner in the state of New Jersey and have
Actually,
appeared.
John, before we get rolling, I don't want to get too far past just the housekeeping item. By letter dated November 21, 2013.
Just do me a favor, use the mic,
I
it
apologize.
picks up better for the
Yeah,
record.
absolutely. I'll try to make that a habit. By letter dated November 21st, 2013, to Mr. Damanak, and actually, per the request during our, we had a informal meeting on this issue, I was requested to submit any documentation in advance so that everyone had it to review. We made a submission of an expert report, and we made a submission of basically the original application package. And we, in order to sort of facilitate this process, we pre-marked those documents. So those packages should have come at least to Mr. Damanak. These documents have been pre-marked as A1, which was the cover letter submitting the application, and then sub-exhibits A1A through A1R, which were the actual submittal documents, all the application forms, the checklists. The other exhibit that we submitted was Mr. Damanak's August 7th, 2013 email, and we pre-marked that as A2. So just for the sake of the record, I want to make sure we're all in agreement that those are marked as exhibits in the proceeding. We sent them in actually with exhibit markers on them, so we're going to be utilizing those exhibits, so I just, sort of a housekeeping thing. So going forward, we'll refer to A1 and A1A through A1R. We'll refer to A2 as Mr. Damanak's August 7th email with the deficiency items, and we will eventually mark Mr. Washburn's expert report as A3. And I believe there'll be one more exhibit through Mr. Chadwick's testimony. So unless there's an objection to that procedurally, I just want to make sure we had the record straight. And we will, the items that have not been pre-marked, we certainly will mark along the way. So, John, my apologies for your interruption. If you want to give a little bit of your background as to your expertise and your, particularly your experience in Franklin and other municipalities
I
as...
think the chairman's accepted him,
You need that for the record, that's one thing.
but he's been here 100
Accepted
times.
him, he's been
I-
here a
I-
million
I'm well aware of Mr. Chadwick's role in Franklin, but John, if you don't mind, without taking a lot of time, just very briefly, your background in terms of your qualifications, particularly with regard to Franklin.
I was the township planner in Franklin.
John, you're going to have to,
Township planner in Franklin in the mid-'70s through '80s. Participated in the first and second affordable housing plan certification process. Drew substantially the portions of the ordinance now.
Your mic on, John?
you're going to have to...
Your mic on, John?
Is it on?
Yeah.
Yeah, so you just got to speak loud.
Very close. And have been providing services to municipalities and the private sector for a number of decades. I'm a licensed planner in the state of New Jersey and appeared before all the superior courts in the state of New Jersey.
And just one more question. You've reviewed, in your role as a planner for other municipalities, applications, particularly with regard to completeness. Have you had experience with that?
Yes, I do. I do it on a daily basis.
Okay. And with that background, John, if you could just start with the history of this
Why
site.
don't we hand out the exhibit?
We can do that.
The exhibit is, you can glance at it as I speak. Ron described the property. The exhibit consists of 3 sheets. I think this is from Bing, yes, showing the site in an up-close version, showing the general area on the second sheet, and the current existing zoning plan for the municipality for this portion of Route 27. And Ron described very briefly, it's approximately 7 acres in size. It abuts Hempstead Gardens. It would come as an individual
Not yet.
application. It was submitted under a use variance CD3 because we did not comply with the 10-acre minimum requirement and could not cure that.
Okay, just for the housekeeping, you're marking this 3-page doc, 3 photos, or 2 photos and a grid, I guess. A4?
Would actually be A3.
I thought you said the expert report was A3.
We did not pre-mark the expert report
Okay.
yet, so it would be a little out of order.
Okay.
That'll probably become A4. So A3 will be this 3-sheet set that Mr. Chadwick is referring to.
Okay.
The next point is in historical, Dunbar Homes has been looking at the redevelopment of the site for 3 years actively. It isn't as if the township decided to adopt an ordinance and Dunbar Homes decided to submit an application. We had an application in process. Quite obviously, you do not prepare, we got a notice 10 days before the hearing. You do not prepare these kinds of documents in 10 days and submit them. Although there was certainly a pushed up date to get the file. The checklist, which appears to be key to your determination of whether or not we had an application or not. Clearly, the paperwork that has been described by Ron, we had a physical application. There's no question about that. The next thing is, does this application require to be complete? My working with the land use law over the years is the land use law in 1976 is when it was adopted, created completeness. There was a development application and there was a completeness process. And the reason they did that is because towns would get applications, they didn't like them, they wouldn't act on them. This forced municipalities to review an application and tell them whether it was ready for hearing, or if it wasn't, why. Up until that date, they could bury these applications. You'd have to go to court to get it heard. The checklist that we have, there are 2 checklists for our application, for use and for site plan development application. The use checklist we comply with. The site plan application, which is the detailed items 1 through 12 from Vince, when you look at those items, is the quality of this application rise to a complete application with details? They wanted an additional set of 4 additional sets of plans. One area it says 21 copies, another area it says 25. They wanted a signature on a disclosure form, an additional signature. They wanted additional copies of drainage calculations. More fees because we're no longer, under Vince's interpretation, we're no longer a D3, we're a D1 application. Generates more fees. We didn't believe we were a D1 when we filed. We wanted a letter to DOT. Land use law specifically says that any application would be subject to approval of outside agencies. It is in your checklist. We have supplied it. The fact of the matter is we have 3 driveways on Route 27 now. Our application will eliminate one of those. The key map didn't show the zone boundaries. The location map speaks to 200 feet from the property boundary. There was aerials, there were location maps. It needed a sealed survey that was provided. There was a absence of the base datum source. Contours and elevations were all provided. The amount of domestic water and the method of solid waste were detailed in engineering reports. The notes were not stated on the site plan itself. And item 12 was showing existing and proposed topography. Those items were there. The issue becomes, in terms of deeming it incomplete, whether or not there is a substantive information missing from this plan or not. My judgment, there is not. However, if you take the technical aspect, if there was 3 Ts and we needed to cross all 3 and fail if you don't, then we fail. I don't believe that's the purpose of what the statute was, which the 2 attorneys have discussed. The purpose was to have a quality application. This is a quality application. My judgment, looking at the entire application, is that we did submit an application. I can't fathom how you could come to the conclusion that we did not submit an application. The fact that you have made a regulation within your ordinance and inserted completeness to make something that you have to file and pay substantial fees for doesn't become an application until somebody says it's complete doesn't make sense as I read the municipal land use law, and because of the statements I've made at the outset.
John, one quick comment, just so that the record is clear, is that you made a comment that you met all the requirements of the use variance checklist, and that's just not factually correct. Several of the items, including the drainage calcs and everything else, are in that checklist. So just so that it's clear, we can discuss all your other items, but you didn't meet the requirements as per our checklist, as per our ordinance for both the use variance and the site plan. That's just factually inaccurate.
Just as we're keeping the record clear, Mr. Demack, when you refer to your review of the use variance checklist, what in particular are you referring to?
We have in section 112-300 of our ordinance, the use variance requirements. And we use that to create the checklist verbatim. But the section that I'm using is 112-300, which one of those, and we could go through them all later, but one of it is clearly the drainage calcs, and there's some others. So you did not meet the ordinance requirements, and hence the checklist requirements for the use variance application. Just wanted to make that clear.
And not to be redundant, but it's your position that section 112-300 is what governs the completeness requirement for use variance.
300 are the ordinance requirements for the submittals that are required for an application for development. You don't have an application for development unless all those submittals, as per the MLU and as per our definition, until those are all submitted. Whether you want to call it completeness or whether you want to call it by definition.
I'm actually asking a different question. You review applications for development for completeness. That's what you do, correct?
I review applications for development for completion.
Okay. And when you do that with regard to a use variance, I'm just trying to, it's not a trick question or anything, just trying to understand the standard which you use. Is it correct, am I understanding you correct, that you use Section 112-300 as the standard to determine whether an application is complete or not complete?
I use it to determine whether it's complete and whether it's an application for development, yes.
Okay. Not sure I understand how it could not be an application for development, but my question is very direct. Forget about application for development. Just in terms of deeming something complete or not complete, what standard do you use when you have a use variance application? Is it Section 112-300?
I use Section 112-300 to determine if an application is complete and if it meets the definition of application for development.
Well, if you could just answer my part of the question.
I did answer it, and you can ask me 100 times, I'm
you-
going to answer it the same thing, because you're mixing terms, and...
I'm not
you're-
mixing terms at all.
Well,
There's
I believe
there's a
you are.
particular provision in the land use law where there's a process to deem something complete. I just want to make certain what you use as your standard. I heard you quite clearly say that it's Section 112-300.
112-300, and there's also section, in regard to the use, there's Section 7, fees, because obviously the fees have to be...
Fees, of course.
Fees have to be also submitted,
Right.
so, to be
I
clear.
think, I'm not looking to argue with you.
No, neither am I.
It's Section 112-300, in terms of deeming something complete is what you go by. You may use it for other purposes, I understand, but
Yes.
just in terms of completeness, that's the section that you use.
Yes.
Thank you. I just had one follow-up question for Mr. Chadwick, and you may have said it, but just a point of clarification. You've, in your testimony, you reviewed the 12 items that Mr. Damanek set forth in Exhibit A2, the August 7th email. Would you characterize any of those items as material or substantive in terms of, the board's ability to review an application?
No, they are not substantive. They are not substantive.
Okay.
Just for clarification, this is drawn the site plan part of the checklist?
Correct.
Okay.
Actually,
I think it's for both.
I think it was for both. Mr. Damanek's August 7th email, Exhibit A2, speaks for itself.
Okay,
But
the reason
just so it's clear, it's the only completeness review we received. So whatever he was communicating to us, this was the only completeness review we received.
Okay, the reason I asked about site plan was because I think that John had testified that this related to the site plan, but, okay.
The review and the email related to, because they submitted for a use variance and site plan. So both checklists and the fee schedule for both needed to be used. And the email was all encompassing. I didn't send one for the use and one for the site plan. It was all encompassing.
I have nothing further, Mr. Chadwick. If the board has questions, we'd be happy to entertain them.
I have a question, Mr. Chadwick. I just wanted to get some clarification. You gave us some opinion, I think, as to, with regards to the township's definition of application for development, correct?
Correct.
Okay. Not a trick question. And I was unclear as to what you said, and I want you to clarify for me. I didn't want to, I thought you said something along the lines of, well, I'm not going to do that. Tell me, what's your opinion of that definition?
The definition follows behind the municipal the statute that is under discussion that we believe supports our case.
Okay.
meaning once you submit an application, that freezes the zoning. The issue of completeness is something that I gave you my opinion earlier on, that comes in is the process of getting to the public hearing process. The physical effort of submitting the application is what we did. This application was certainly not a sham. It had full engineering in terms of water, sewer, drainage, topography, building, and architectural plans. Those are the substantive items of an application. The fact that somebody didn't sign a line on the W-9 form is not substantive. The fact that we saw one section you want 21 copies, and another section you want 25 copies, the absence of 4 copies is not substantive. There are some other items in there, and in my judgment, as Mr. Shermanowitz has stated, and Pat, you've discussed with him, I think we submitted a development application.
But under the current definition in the ordinance, section 1, is it your opinion that what was submitted complies with that definition?
Your definition?
Yes.
No.
Okay. So,
You've woven completeness into a development application. My judgment, that is not what the law says.
okay. Do you know when this definition went into effect?
Sometime after the adoption of the law, it fixed zoning.
Okay.
I could answer
If I
that
tell you-
for you.
I know it.
Answer.
So if I told you they changed the definition on May 24th, 2011, would that make sense?
That's what it says in your ordinance.
Which is well in advance of when this was submitted, though. This whole application or submittal came in July of 2013. Correct?
Yes.
Okay. So I understand what you're saying with regard, or your argument with regards to the date of the submittal of the application. But we can both agree that this definition, though, was long on the books before before Dunbar submitted on July 15, 2013, correct?
Yes.
Okay.
Long meeting was on the books for
Well,
a year and a half.
we gave the dates. Okay.
There is one item I'd like to clarify for the record. I think Mr. Damanek, we may actually agree on something here. I think both sides of the table here have referred to the township's definition of application for development as requiring, to meet that definition, a complete application. And I don't want to concede that is the case. I don't know that I'm not reading the language to say that. It says in that ordinance definition of application for development, it says things that are different than what is stated in the municipal land use law. One interesting section of the ordinance definition is the following, and I quote it, an application shall be certified as complete immediately upon meeting all the requirements specified in the ordinance and the rules and regulations and, dots, close quote. Therefore, your definition of application contemplates a future deeming of completeness. So I think we got a little mixed up in the beginning.
And I think we are in agreement,
Yeah.
because when we're talking about, and John talks about completeness, you're talking about the definition in the MLUL. When we're talking, when our ordinance talks about completeness, it's talking about meeting the definition of an application for development. And to do that, you have to submit everything. Everything that John said about the whole thing about completeness is something that a lot of boards do later on to make sure they have everything. So we're using that completeness term in two different manners. So you and I in that way, are in complete agreement. That in our definition, we're not saying that not only do you have to meet the terms of the MLUL, we're just saying, yes, you do, and by being it complete in the terms of the MLU in our definition means you must submit everything our ordinance requires, not the definition that's used in the MLUL and that we've all used for 20 years for a complete application. So it's used in a different manner. So yes, we're in agreement.
I'm not sure now if we are or we're not, but I just wanted to clarify that your definition of application for development, at least I don't see specific language that says in order to have an application for development under your ordinance, you must have been deemed complete. I don't see that express language. The language, you know.
And I would agree with you. I would agree with that.
It speaks for itself.
Yes.
Yeah, but I just wanted to clarify the record because I think it got a little confused as to what is actually in your ordinance definition. But the definition's the definition. We can't change it, and it speaks for itself.
Question, John. For all of the 12 items, and I might agree with you that a couple of them nitpicky, were there any of them, however, in your opinion, that were substantive in nature?
None
So
of
that,
them,
for example, and I guess Vince will testify, but if the drainage calculations were incorrect, or if the site plan didn't show the existing and proposed topography.
Let's stick with drainage. We
Okay.
did submit a report. They wanted additional copies.
That is false. You did not submit the drainage calculations. You didn't submit them. And that's about as substantial
Well-
as that you can possibly get, because if the site doesn't work from a drainage viewpoint, the site doesn't work. So that's about as substantial as you can get, and those were not submitted. The drainage calculations were not submitted.
What was submitted is a drainage plan. There was no calculations because we're reducing the total site coverage of pavement substantially. All of the drainage facilities exist, and that was shown on the site plan. You don't have to do a drainage calculation.
That is incorrect. You do. It's required by ordinance, and you know it's required by ordinance, and it wasn't submitted. So don't say you don't have to submit it when it says you do, and you know darn well that the drainage calcs needed to be submitted, and they were submitted afterwards. You did submit them, because you knew you needed to submit them. So, and that is substantial. There's no question about that,
We submitted them afterwards because you requested them.
because they're
I
required.
mean, if you want to debate this issue, the
Yeah.
county wrote an approval letter and copied the township on it saying that there's no approvals required because we're not changing the impervious coverage.
I only brought it up because John made a statement
I
about
understand.
that just is not factually accurate, and any board and any engineer will tell you in a site plan, if you do not have the drainage calcs, there is no way for the board to make a determination as to whether the site works. That's just,
I just, Vince and I aren't gonna agree on this, but if you take a piece of property and it's 80% covered with building and pavement, it's gonna wind up being less than 50% covered. You got less water going off the site.
that's not necessarily true, depending on how the site is graded and the types of pipes and how you, that's just not true. That's not factually accurate.
This site
It's just not.
is not much more rolling than this tabletop.
Doesn't make a
The
difference.
site is flat, and the drainage pipes are there, and it's going into
It's not
detention
really,
basins that are already built.
we got to be beyond what even you're looking for from the board with this testimony, right?
Yeah, I was going to
I
say.
was
with-
just trying to
yeah.
respond to Laura.
Yeah, and we were responding to the question. Yeah,
Substance.
yeah. I think the, bringing it back to the main issue, that is what is meant by Section 10.5 of the land use law. What is meant by an application for development, and whether we met that requirement. That's probably the more germane issue for the board to deal with. Unless there are other questions of Mr. Chadwick, we have our second witness.
Any other questions? Great.
Our next witness is Mr. Robert Washburn.
Sir, if you raise your right hand, you solemnly swear or affirm to tell the whole truth, nothing but the truth?
Yes, I do.
you need to actually speak into the microphone, so.
Yes, I do.
Okay. And your name for the record?
My name is Robert Washburn.
Okay.
Bob, if you could give us,
The benefit of your qualifications.
Yes, I have a law degree from Washington University Law School. I have a Master of Laws in Housing and Real Estate Development and Finance from the University of Pennsylvania Law School. I'm a professor of law at Rutgers Law School in Camden. I teach a variety, excuse me, of real estate courses. In particular, I teach land use law, and I've taught land use law for over 35 years. I'm also of counsel to a law firm named Flaster Greenberg. Our main office is in Cherry Hill, New Jersey. I have lectured and written on land use law. I'm also general counsel to the Builders League of South Jersey and the New Jersey Builders Association. One of the things I do for my Builder Association clients is I do legislative drafting and negotiation. On behalf of the New Jersey Builders Association, I actually wrote the original version of the time of application statute, and I participated with my client, with the legislators, and with other interest groups when that legislation was refined, negotiated, and ultimately passed by the legislature.
I would move Mr. Washburn as an expert in real estate
ahead.
and land use law.
And use the mic next time, because otherwise it won't.
I would move Mr. Washburn as an expert in land use law.
That's fine.
Okay.
Accepted, thank you. Before we get you going, Bob, just again, housekeeping item. We did previously submit Mr. Washburn's expert report. It's dated November 20th, 2013, and we'd like to mark that as Exhibit A4.
Okay.
Okay. And Bob, you did indeed prepare this report entitled Expert Report of Robert M. Washburn, dated
Yes.
November 20th, 2013.
Yes, I did.
You did. And could you give us the benefit of a summary of that report?
Yeah, I will summarize what the report says. I was asked to opine on the meaning of the statute that we're talking about, which is the time of application statute, NJSA 40:55D-10.5. It was, became,
Hold on.
I'm sorry.
it was adopted in May of 2010 and became effective on May 5th of 2011. What the statute provides is that a developer has the right to rely upon the municipal land use ordinances that are in effect on the date that the developer submits an application for development, so that ordinances that are adopted by the municipality after that date are inapplicable to that particular application. The statute is not subject to municipal interpretation or modification by ordinance. Section 10.5 begins by saying, notwithstanding any provision of law to the contrary. The triggering mechanism in Section 10.5 is an application for development. And that term was used in the statute because application for development is a defined term in the municipal land use law. And the whole idea of what the triggering mechanism would be was part of the process that was discussed when the statute was drafted and when the various interest parties negotiated the wording of the statute. There was a long period of time, because this statute was pending in the legislature for something like 6 or 7 years. It was a long period of time in which there were negotiations and meetings between various stakeholders. That included the Builders Association, which I represented. It included the municipal engineers, and it included the League of Municipalities. There were extensive discussions on what the trigger should be. And the League of Municipalities' preference was, excuse me, that the trigger would be a complete application. And in fact, there were a few early drafts of the legislation and an actual bill that was submitted, which I think is at tab 10 in my expert report, that provided that the trigger for protection of the statute would be a complete application. There is, of course, as we have discussed so far this evening, a separate procedure under the municipal land use law for determining completeness of applications, and that procedure is in section 10.3 of the statute. So you have to start with the understanding, as we did when we drafted the bill, that there is a provision in the land use law for an application for development and a separate procedure in the land use law for determining completeness. And they are separate stages, the way the land use law is written. Ultimately, and there was a lot of negotiation back and forth, and as I just mentioned, there were one or more bill drafts that included the trigger being a complete application, but ultimately the legislature made the trigger for protection under the statute an application for development, not a complete application for development. Since there was a completeness provision in the land use law, it would have been very easy for the legislature, if it wanted to make the requirement a complete application, because that's already defined in the land use law. But the legislature chose not to do so. I'm not going to summarize all of the different factors that I cited, and I'm not going to go through all the different factors that I indicated in the report that indicate that the trigger was clearly an application, not a complete application. I do that at some length in the written report. I'll just summarize that, number one, there is the plain wording of the statute, which says that rights are vested upon, quote, submission of an application for development. The statute was modeled on and was passed about 5 months after Governor Christie had issued Executive Order Number 2. Executive Order Number 2 imposed the same requirement, a time of application rule, on state agencies, and says the same thing, that it's that the trigger for that is application. I included in the report as exhibits and in my analysis the statements from the various bills that were introduced in the different sessions of the legislature, all of which say the trigger is an application for development. I included the committee statements from both the Senate and the Assembly, both of which refer to an application for development, not a complete application. I included letters and press releases from the opponents of the legislation, primarily the New Jersey League of Municipalities and the New Jersey chapter of the Sierra Club, complaining about the fact that the trigger was application for development, not complete application for development. And finally, I included a press release from Governor Christie's office when he signed the bill in 2010, again reiterating that the trigger was an application for development. If you look at the intent of the statute, the purpose of the statute was to protect developers who spend a lot of time, effort, and money to prepare and submit an application, only to ultimately be frustrated if the municipality can, in reaction to the application, change the zoning and basically pull the rug out from under the developer. In order to protect that investment of time and money and effort, the trigger would have to be application for development, not a later date in the process, such as a determination of completeness. One of the things that we talked about during the drafting process was the fact that many municipalities have extremely extensive completeness checklists, to the extent that it's virtually impossible to submit an application that's going to be determined complete without further additional submissions. And therefore, the legislators realized that if we made the trigger completeness, it would basically frustrate the statute, because in many towns, it's almost impossible to be determined complete. So you would never be able to get the protection that the statute was intended to provide. In summary of that point, every piece of legislative history that I'm aware of, and all of the commentary that I'm aware of, and I included a lot of it in the report, confirm that the trigger for Section 10.5 is an application for development. There is absolutely no support for the proposition that the trigger under the statute is a complete application. I also included discussion of several judicial decisions. There has not, to my knowledge, yet been a case that was decided specifically on Section 10.5, the time of application statute. However, the statute came up in other contexts in 3 judicial opinions, and all 3 of them decided the issues dealing with the statute the same way, which is that the trigger is a application for development, not a complete application for development. I also was asked to determine whether the submission that Dunbar Homes made on July 15th, 2013 qualified as an application for development. And my conclusion is that what Dunbar submitted was an application for development. It is entitled to protection under Section 10.5, and the zoning board must hear and decide the application under the ordinances that were in effect on July 15th, 2013, as required by Section 10.5. I did also receive a piece of correspondence dated November 22nd, 2013, from the zoning officer, in which he takes the position that since the application was not complete on July 15th, Dunbar is subject to an ordinance which took effect on August 5th, 2013. It's beyond the scope of my testimony to tell you whether that application was complete or not on July 15th. I think Mr. Chadwick has testified to that. However, it is my opinion that the completeness of the application, or lack of completeness of the application, is irrelevant under Section 10.5. Section 10.5, as I previously said, clearly freezes regulations when the application is submitted, not when it is determined to be complete. In his November 22nd memo, the zoning officer takes the position, holding aside for the minute what the Franklin ordinance says, but I think the zoning officer takes the position that under the municipal land use law, the only time that an application exists is when it's declared complete. That is not what the municipal land use law says. That position ignores the statutory distinction, which is very clear in the land use law, between an application and a complete application. Section 3 of the land use law defines application for development. Once an application is filed, that triggers the completeness process under Section 10.3. Once the application is determined to be complete under 10.3, that then starts the MLUL timeframes for decision, starts that time running, and also allows a board, planning board or a zoning board, to schedule a public hearing at that point. If an application had to be complete before it was an application, there would be no need for this two-step process. It's therefore my conclusion that Dunbar Homes submitted an application on July 15th, 2013, as that term is defined in Section 3 and by reference in Section 10.5 of the land use law. I also reviewed, for purposes of my report, and I mentioned this in the report, that the zoning officer sent an email on August 7th, 2013, which contained these 12 completeness requirements. And in that email, the zoning officer refers to Dunbar Homes' submission at least 4 times as being an application. And if Dunbar's submission on July 15th was not an application, there really would be no reason to have a completeness review. It's either an application or it's not. And I think the zoning officers, again, holding aside the ordinance, which I'll talk about in a minute, the zoning officer's interpretation basically conflates application and complete application. The position seems to be that there's no application until the municipality determines that it's complete. But that's simply not what the MLUL provides. The MLUL creates a 2-step process. A developer files an application for development, and that then triggers the completeness process. And if you look at section 10.3, which is the completeness section, it specifically says, quote, "An application for development shall be complete," and then goes on to explain the completeness process. So it's very clear that the MLUL contemplates and makes a distinction between an application that gets filed and then a completeness process under 10.3. I also looked at and included in the report a review of the Franklin Ordinance definition of application for development. And frankly, it is my professional opinion that that section is invalid. It requires that the township, it looks like it requires that the township find the application is complete before it's a, quote, application. And we just had a debate about that. But even if that's not what it says, it differs from the MLUL definition of application, and it ignores the difference between an application and a complete application. I cite in my report some judicial decisions that hold that a municipality cannot modify an MLUL definition. So I think that the definition in the ordinance is invalid under the MLUL. This is not like the Department of Environmental Protection, which has a number of regulations that specifically say municipalities can regulate the same thing provided that it's more stringent. The MLUL, as I've quoted in the report, says you have to follow the MLUL, and that ordinance definition does not.
Thank you. I have nothing further, Mr. Walsh.
Any questions?
Bruce, can I go first?
Yeah, go.
Okay. Okay. It's your testimony that a township cannot change the definition of an MLUL definition?
A municipality cannot change a mandatory definition in the MLUL.
Okay. And what makes it mandatory?
Well, I can only say that the case law indicates that if the MLUL creates a flexibility, that a municipality has the authority to exercise that flexibility.
Okay.
But if the MLUL does not contain any flexibility, I think a municipality has to follow MLUL definitions.
Okay. And does it not make that mandatory by simply saying the term shall indicates mandatory and may indicates permissive?
Not necessarily, not under the case law.
Okay.
There's also some case law that says if the MLUL contains certain options, that a municipality doesn't have to follow any one of them.
Are you familiar with Rumson Estates versus the
Yeah.
Borough of Fairhaven?
Yes, I am.
Okay. And that is a New Jersey Supreme Court case, is
Yes,
it
it
not?
is.
Okay. I just want to read to you exactly what it says. Okay? Because quite frankly, it's completely contrary to what you state in your expert report, where you don't cite this case at all. In fact, you tangentially hit other cases that I don't think say what you say they do, but let's just read exactly what this case says. And I think it's important to say what the question presented to the court was, because I think that's important. And I highlighted it here. So, there are two basic issues presented in these appeals. The first is whether a municipality may enact a zoning ordinance that alters the definition in the municipal land use law, MLUL. The second talks about something not relevant to this, okay? We hold that with a narrow exception, and I'll give you the exceptions. The MLUL does not preclude a municipality from adopting a zoning ordinance that defines terms differently than the definitions in the MLUL. And I will state to you, counsel, that the case goes on to say that the very distinction as to what is mandatory and what is permissive is the language shall and may. And so I ask you, does the definition in the MLUL concerning application for development say shall?
I don't believe so.
That's right, it doesn't. So, now, why don't you talk about this case in your papers?
The New Jersey Supreme Court held that a municipality can modify by ordinance the non-mandatory definitions of the MLUL. What Rumson Estates dealt with was the definition of floor area ratio for the purpose of determining residential density.
Right?
The definition of residential density in the MLUL was not mandatory.
Because it didn't use the term shall.
No, because the court based its decision on the fact that Section 65B authorized municipalities to use any number of devices to control residential density. So that the court said it's okay to use a net density calculation. It doesn't have to be a gross density calculation. That's not that kind of flexibility which the court relied upon in Section 65B doesn't exist in the MLUL definition of application for development. And it's my opinion that Rumson certainly doesn't authorize a municipal ordinance to ignore what the MLUL defines as an application for development and combine it with the definition of a complete application. They are separate provisions under the MLUL.
Well, I think they still are separate under even the definition, but I guess that's not for you or I to determine. So you're saying that the definition of an application for development, meaning what is complete or not, is more important than a definition for density.
No, what I'm saying is that the court said that the land use law gives municipalities flexibility in determining how to fashion residential density standards.
So you think that case is limited to speaking to the definition of floor area ratio?
No, that case...
Well, that's what you keep saying.
No, that's not what I keep saying. What I keep saying is that if the MLUL permits municipal flexibility, municipalities can exercise it. There is no such flexibility in the application and completeness requirements. They are separate and distinct requirements.
So when the court says, although a defined term will have a specified meaning when it's used in the municipal land use law, municipalities are not forced into that definition and have the power to alter to serve recognized goals. You're saying that that doesn't apply to this?
It does not.
Okay.
It's within the context of the opinion.
That's your opinion, your opinion, your
That talks about Section 65B.
I just thought it was curious that you didn't mention this case at all in your submission.
Well, as I'm indicating, I don't think that it controls in this matter.
So they go on to say the validity of a land use ordinance or regulation is governed by the MLUL. In sum, it is valid if it serves the purpose of zoning. So, let me ask you, when you cite to 55D 10.5, and it says, those development regulations in effect on the date of submission shall govern. It says that, right? You've said that several times.
Yes, I believe that's...
Okay. Now, let's go ahead and look at what the definition of development regulation is. Because clearly, that's the term they use there. So the development regulations, which are in effect on the submission, they control. Development regulation is defined as, development regulation means a zoning ordinance, subdivision ordinance, site plan ordinance, official map ordinance, or other municipal regulation of the use of the development of land or amendment thereto adopted and filed pursuant to this act. Correct?
Yes.
Okay. And would we agree, or can we agree, that that then is the definition of the very term used in 40:55D 10.5? Correct?
Term development regulation.
Yeah.
Term development, yes.
Right. Now, we've, aside from the development ordinance, which changed this zone not to allow townhomes, can we not agree that the township's ordinance definition was on the books before July 16th, 2013? Can we agree on that?
Which definition?
The township's definition.
Of application for development?
Yeah.
Yes, it was.
It was on the books before. And do you not agree that, whether you agree with this definition or not, it is a development regulation pursuant to that definition, isn't it? And it was on the books before the submission, was it not? And I'll follow it up. So wouldn't it then control?
I think it would control if it were valid.
That's where I needed you to go. So, are we not here deciding whether or not this ordinance definition is valid or not?
That is part of my report.
Okay, but are you not here to tell the board that they must somehow either overrule, disregard, or change, edit, whatever you want to say, this definition?
My testimony is that the board should follow the definitions and the procedure in the municipal land use law.
Okay, but I asked you a fairly straightforward question. In doing that, in doing what you say they're charged with doing, or what you want them to do, does it not mean that they have to either ignore, overrule, edit, or somewhat alter this definition? To get to where you want them to go, don't they have to do that?
They can't, I think, follow that definition and comply with section 10.5.
Okay. Now, that brings me back to where I started tonight. Where does the Zoning Board of Adjustment have the power to disregard its own ordinances? What authority, and certainly, and I already read into the record 70A, doesn't, and that's what you're here for, but is there any case law or any provision of the MLUL that says the zoning board sits in a judicial role and has the luxury of saying that its own definition and/or ordinances are not valid?
I did not research that for this report. However, I believe there is New Jersey case law that, and it's primarily, I guess, the exhaustion case law, that says that if a applicant is raising an issue of statutory authority or validity of an ordinance under a statute, that they would have to exhaust remedies by going to the zoning board. And I think that's the case law that distinguishes statutory interpretation and ordinance interpretation from constitutional issues in which you don't have to exhaust. But I have not reviewed that case law for purposes of this report.
Okay, fair enough. You're an expert in land use law, we've qualified as that, but you're also a lawyer. Do you not think it is a completely legal determination that the board would have to make in order to address the application for development definition in our ordinance?
I think that zoning boards in New Jersey are considered to be quasi-judicial bodies and can make that kind of decision.
Completely illegal call?
Yes.
I mean, I agree they're quasi-judicial, but should they be making 100% legal determination?
I'm not sure I would characterize it that way. I think the board has jurisdiction to decide the questions before it on this application.
Okay. Now, I wanted to ask you, you give a lot, you spend a lot of time in your report talking about the reasoning behind the change of the law, correct?
Yes.
And a lot of it, is it not, is based upon inequities that builders and landowners had prior to the change of the law, correct?
That is generally correct, yes.
It's because maybe they spent a lot of money and a lot of time, and then the townships and towns, and cities were able to change it at the last minute before they got to the end zone, so to speak, correct?
Yes.
Okay. Is it your opinion now that the law has changed, and I think we can effectively say that the builders and the landowners have, it's flipped on them now. Is it your opinion that any submittal triggers the date of time of application? Or is there some degree of, that you look at what is actually given? I mean, you can't hand in a napkin with a thing written that says, "I'd like to build the townhomes here," can you? Or do you think you can?
I think that's an open question, the way the statute is written.
Okay,
There has been some commentary that says that while to trigger the protection of the statute, an application doesn't have to be complete. It has to be more than a napkin.
okay.
And possibly, when the issue gets to court, the courts may develop a bona fide application standard.
Okay, and they
To
don't have,
avoid the napkin problem, but we haven't gotten that far yet.
okay, and I haven't seen any case law that.
No, I haven't either.
Okay. So, we don't know what is more than a napkin and what is fully complete. I mean, nobody knows that, and we don't have any guidance.
You could ask Mr. Chadwick, I think I know what the answer would be,
Okay, I know too.
in this case.
All right, but let me ask you this. Just looking at the timeline, I mean, you talk a lot about equities. Let me ask you, don't you think it would be inequitable if a very minimal submittal was given for it to actually trigger the time of application? Don't you think that would be inequitable to a township?
It's hard to speculate.
Okay. Well, do you know anything about the timeline as when this township started the process to change the ordinance?
I do not.
Okay. Now, do you know that Dunbar submitted their submittal on the day before the town council here adopted the change of the ordinance?
I think I read that in some of the material, yes.
Okay. And if I told you that on November 21st of 2011, Township Planning Board issued a resolution commencing the review of the redevelopment. And then in March of 2012, they created an ordinance to recommend the change to the master plan. Now, that's in March of 2012. And then it was on July 16th. Now, there was many public hearings in between there. And it was on July 16th that it was adopted by the council, but it was on July 15th that Dunbar handed in their submittal. They fell over the goal yard line. Now, do you think there's any inequity there?
Can I answer it this way? When we were negotiating the statute, the representatives from the public side, the League of Municipalities, the municipal engineers, said, well, look, we're not always trying to torpedo developers. We get an application and we say, gee, we didn't know that could go there. We really didn't know that our ordinances permitted that. We really don't want that there. And their position was, we should have some flexibility to get around this statute to correct those inequities. And the legislature listened to that. And the answer that the legislature gave, which I think I mentioned in the report, was that unlike most legislation, which becomes effective upon passage or within 30 days or some relatively short period of time, the legislature delayed the effective date of this statute for 12 months over our objection. And the reason the legislature did that was to say to municipalities, we get your point. You should look at your master plans. You should look at your zoning codes. And if there's something you don't like, you got a year to change it. Because once that year comes, if an application is filed, the rights are vested. So that was handled by the legislature. I can't answer for Franklin Township's time frame or motivations. That's not my job. But I'm just saying that that particular issue was handled in the delayed effective date of the statute.
Okay. Chairman, I don't have any further questions.
Anything else?
I just had a couple of simple things, I think. One, you used the word conflates.
Together. Saying that it basically says that application and complete application are the same thing, whereas my reading of the statute is they're two different things. There's an application, then there's a completeness process.
Okay. Are we collapsing the MLUL with the town's ordinance? They're both standalone ordinances, yeah? Or one's a law, one's an ordinance with a bunch of regulations about how to do it, yeah?
Well, it's my opinion that a municipality gets authority from the MLUL, that's the enabling statute.
Yeah.
And that every municipality can adopt its own regulations, but has to do so within the guidelines set and can't conflict with the MLUL.
Good. Somebody said, I don't know who it was, that if you have a big, long checklist, it's very complex, it's impractical to basically have a complete application according to the municipal, application process.
Yes, in some towns that's true. We had discussion about that when we were
And that was-
drafting the bill.
And that's probably the year for the towns to get their act together.
The getting of the
Is that
act together was to
related?
make substantive changes in ordinances.
Yeah.
Was to allow municipalities to examine their master plans and their ordinances to avoid people coming in and asking for things that the town didn't want, filing an application and getting vested rights. So the legislation gave the towns a year to re-examine their master plans, make whatever changes they thought appropriate in order to not get caught short, as a method of making it equitable on the other side.
Well, don't you think that this township's changing its definition was part of the township's being prepared for the change?
That was not the discussion that led to the one-year delay.
Well-
One-year delay was to handle unwanted uses that might have been permitted in zones that would catch the town by surprise. That was the discussion, that was the purpose of it.
Okay.
Let's see, I had one more.
My
What-
turn?
what I-
If
Go ahead.
if we got two things going on here, I mean, the integrity of the township's actions, I mean, the zoning officer's actions, where he views the situation, that he wants to get this complete, and there's a bunch of stuff missing. And he determines that maybe one or two of things he really needs to have as calculations, but he makes a list, and so that happens. It takes time. But, so he's working on it. It's not a workable situation or application. The integrity's out until he's complete. He's got his checklist checked off. So he's operating under the municipal ordinance to be complete. And then you're saying that it's already complete.
No, I'm saying it's an application,
It's an
and
application,
there's a completeness process.
and there's a complete,
And the statute we're dealing with, 10.5,
you have to go back to the beginning of
talks
it.
about application.
Our ordinance essentially merges
That's what he's
the
saying.
definition of application and completeness process. I think when he said conflate, that's
Right.
what he was talking.
Yeah.
Right.
So-
See, what really bothers me a lot about
That's
this is I can submit
Conflict.
an application for development and give it to you, and you'll say it's an application for development. I can give it to your partner, he may look at it and say, it's not, right? But you submit something to the township, and they give you a checklist. That seems to me a pretty darn objective thing to look at. It's in writing. You do this, it's done. You do this, it's done. So I don't have
But that's exactly what the MLUL permits.
Yeah,
Once-
and
Once you
I
have
can
an
speak on
application
Yeah,
for
but
development,
what's to prevent
Vince is
whole
going to talk on it.
mass of builders? This law or ordinance that we developed took a couple of years in process. People know that, in the industry, know that that's going on. So you come in on July 15th with 10 other people with applications
Bob, maybe I
that are
can,
baseless?
maybe I can address that in my memos really quick, because we've spent a lot of time talking about application for development and completion. And everything that Mr. Washburn talked about the difference between application for development and completeness, I'm in total agreement with. They're two separate paths. The only path that I looked at in regard the time of application rule and whether it was a D1 or D3 was whether an application for development was submitted. That's the only thing I looked at. Nothing to do with the completeness. We have a definition that defines application to development that specifically says, among other things, you must submit everything that is required as per our ordinance. The municipal land use law, as you know, specifically says exactly the same thing for application for development. Irregardless of whether you use our definition or the definition in the municipal land use law, you need to submit, to have an application to development, by both definitions, everything that's required by our ordinance. As has been testified prior and has been put into the record as exhibit, my email was exhibit A2. There are 12 specific items that are listed. Each of those 12 are in our ordinance and are in our checklist. None of those 12 were submitted until after the date, the effective date of the ordinance. I mean, that's unequivocally, and John and I had an argument about whether those are substantial or not. We can have that argument, and you may litigate that further. But I think we can all agree our ordinance lists those 12 things, and they're also listed in our checklist. They were not submitted. If the application for development in the MLU and in our definition says to be an application for development, you must submit everything in our application that's in the ordinance, and you didn't do it, it's not an application for development.
Mr. Dominic, I appreciate your comment. I want to clarify something because it's a little bit circular and confusing to me. If I understand what you just said, and your first statement was you agree with Mr. Washburn that there are these two separate paths, to use your term.
Correct.
You have an application for development and you have completeness.
Mhm.
But as you develop that thought, I think I heard you say that in order to have an application for development, you must satisfy the requirements for completeness.
Oh, no, I did not say that.
Well,
I absolutely did not
then
say, I said to have it, let me finish.
Yeah.
What I said.
It sounded like that's what you said to me.
And I'll clarify that.
Actually, a good question for you to answer would be, what would be the difference between an application for development and an application that's deemed
Well,
complete?
let me first clarify that the way you characterized what I said, you misunderstood me. To be an application for development, you need to meet our definition. Our definition specifically says you must submit everything that's required as per the ordinance.
And that's not the same as completion, a
No,
complete application?
It is not. It is absolutely not. And the municipal land use law says exactly the same thing, that you must submit everything required by ordinance. I don't have the ability to have an argument and say, well, you know what? The
Then-
drainage calcs are required by our ordinance, but you know what? It's not substantial. Now, that's a completeness thing. I can do that in completeness, but I can't do that for an application for development. That's why we're talking about two separate
What
paths.
standard do you use for that first path, to determine whether something's an application for development? What is the legal standard?
The legal standard, as per both our ordinance and the municipal land use law, are the things that are listed in our ordinance. And they're listed in 192 for the site plan requirements, 300 for the use variance, and Schedule 7. They're clear-cut, and we base
hear
a
you.
checklist, which is exactly
And
verbatim for that.
those sections you just cited would be the same section you would use to deem an application complete? You don't have a separate section. It's the same standard. It's circular, Mr. Dominic.
No, it's not. I would
It
disagree
absolutely
with
is. You have one set of standards. Pardon me. You have one set of standards. You've cited them clearly. You've given the ordinance section, and you use that standard to determine whether something is an application for development, and you use that standard to determine whether it's a complete application. You're reviewing an application under the completeness standards to determine whether it's an application at all. It's a big circle. It doesn't make sense.
Does the municipal land use law in our ordinance, do they both not say that to be an application for development, as per the definition, you must submit everything that is in the development ordinance? Do you agree with that? That's just a factual. Do you agree with that?
I understand your question. When I gave my introduction,
Do you disagree or agree with
I said
that?
that if you allow me to answer the question.
Well, it's a
when I
yes or
get-
no, it's a yes or no answer.
You're not cross-examining me. I asked you a bunch of questions, you gave your answer, and I stopped when you gave your answer, okay? And allow me to answer the question as you asked it. When I introduced this application, I said that the applicant's understanding and position as to what the township is requiring is that you require a complete application in order to get the benefit of Section 10.5. That's how we understand your position.
That's not
And
my
if-
position, and
Well,
I've
if you're
stated that.
utilizing,
I've
if
stated
you're
that
utilizing
a
section,
dozen
the checklist in the ordinance,
You can-
then you are doing a
You can do
checklist, you're doing a
You can do your
completeness
little
review.
circular thing all night long, and I've just reiterated it probably a dozen times tonight. There's a definition for application for development, that you must submit everything that is required as per the 3 ordinance sections. There's no question, in fact, that you did not submit everything that was required by ordinance. There's also no question, in fact, that both our ordinance and the municipal land use law require you to submit those to meet the definition of application for development. You can talk all night you want about completeness and try to confuse the issue. Forget about that. You did not meet the definition of application until after the date that the ordinance was in effect. That's just
And
the
that
fact.
was the date you deemed us complete. You sent us a letter deeming us complete, correct?
Yes.
You did, okay. I understand your position, and I respect your position. I disagree, but I respect it.
Which is fine.
Any other witnesses or any other questions here? Anything?
I do have actually a question or two of Mr. Dominic, if I may.
Sure.
Yeah. You, in your memos, in response to our appeal,
We should probably mark those, right? Do we want to mark
I
those?
have no problem marking those if you wish.
Just for the record, right?
Absolutely. Mr. Bradshaw, how would you like to designate those? I think there were 2 memos by Mr. Dominic.
Yeah, there's one of November 22nd and one of October 30th.
November, October 30th.
Was it October 30th?
Yeah, October 30th was the first memo, and November 22nd was the second memo.
Okay. You want to mark them Board 1, Board 2?
That's fine.
We'll make it we'll make the October 30th, 2013 as Board 1, B1, and November 22nd, 2013 as B2. In one of those memos, and actually very clearly in your testimony tonight, Mr. Dominic, you referred to the certain ordinance sections which you used to review, and I don't want to get into debate with you again, so don't hold me to the words, to review an application and/or completeness. Is that fair enough? Okay. One of those sections that you referred to, and just give me a moment to gather my documents here, one of those sections that you referred to is section, of course, now I'll have trouble finding it, just bear with me. It is definitely here. Here it is. One of those sections you refer to is section 112-300, and I believe you stated that that is the checklist for a use variance application.
Correct.
Okay. I'm going to just, if you don't mind, and you can double check me, I'm going to read the introductory paragraph to that section. It says, for the purpose of an application pursuant to the provisions of NJSA 4055D70D, wherein the applicant has elected to submit a separate application for any required approval of a subdivision, site plan, or conditional use pursuant to NJSA 4055D-76B, the following information and documentation shall be necessary to constitute a complete application for the use variance. That's the introductory paragraph, right? So this checklist, if I've read that correctly, applies to an application pursuant to Section 76B of the land use law, which commonly is referred to as a bifurcated application. Is that correct? It seems to me that the language there is quite clear.
It requires anytime you submit a use variance, correct?
No, actually, if you take a look at it and listen to what I read, it says it applies when you're making that application, and I'll read the words again, pursuant to NJSA 4055D-76B. I could read that section of the land use law, but I hope that since it is a zoning board that you'll recognize that that's the bifurcation section of the land use law. So my reading of this, and perhaps Mr. Bradshaw wants to weigh in, this checklist would apply to a bifurcated application.
I don't have it before me.
It's in the ordinance, it's section 112-300, use variance.
It's in my memo, it's attached to the memo. Purpose of an application.
I don't have any attachment.
Yeah, I don't mean to catch anybody short, and you can certainly review it, but I would submit that this section...
I think I'd prefer to read it, and I can give you an opinion after I read it.
You're welcome to do that, but I actually just read it out loud. It's a very short section. It seems quite clear to me, I don't think there's any ambiguity, that this checklist applies to a bifurcated application. I'm not sure what checklist applies to your just a straight use variance application where there is no bifurcation. The language of section 300 seems quite clear. The other question I had for you, Mr. Dominack, is we have marked in this proceeding two exhibits, one being the exhibit A1C, which is a site plan checklist, and exhibit A1D, use variance checklist. And those are a little bit different documents than what appears in the ordinance. Are you familiar with those checklists?
Yes,
Actually, the ones with the boxes where you put the checks in them?
yes.
Okay. Is it your opinion that those are governing the documents as well? Because you have to submit those with the application. What actually governs completeness?
Well, let's miss it, we're mixing the terms.
I won't use that term. I don't want to get into
just-
debate. What governs, let's say?
What governs is the ordinance.
What governs is the ordinance. So those checklists that are part of your application package and you have to submit are not binding documents.
They are not binding documents, no.
And why do you draw that conclusion?
Because they're meant as a reference, the only our ordinance is binding, these are meant as a reference to assist the applicant and us in determining whether an application has been submitted or deemed complete.
So there is a possibility that there's a difference between the ordinance submittal requirements and the actual checklist document.
At times there are, due to, things changing and everything before things are changing.
Right, and if I might give you an example of that, something we ran into in this application is the actual checklist where you check the box says you must submit 20 copies of a plan, and the ordinance says you must submit 24 copies of a plan. And that in and of itself is a great example of why we're here tonight. It is very difficult for an applicant to submit an absolutely perfect, pristine application when you have, you gather documents from the town, you download them from the internet, or you go to Mr. Dominack's office and you say, I got the application forms, great, and they say one thing and the ordinance says something else, and then you get an incompleteness letter saying, you owe us 4 copies of a plan, you're incomplete. And you submitted 20 because you read the darn forms that the town gave you. So that's what I want you to at least consider. There's ambiguity in this process, and that's part of the reason why you have Section 10.5 of the statute, and also part of the reason Mr. Washburn drew the conclusion, and why the legislature drew the conclusion they did, that a complete application is not required for protection under 10.5.
Something I totally appreciate what you said, and some of what John pointed out, I would agree with. 21, 24, copies of the same thing. I mean, I think that that is de minimis, and I would deem that complete. The question I have, however, is that there do seem, of these 12, and I haven't got the expertise to completely second guess our zoning officer, but if he says that drainage calculations are necessary, or that the site plan does not show certain things that it should, like the existing topography and proposed topography, or the methods and placement, well, the methods and placement of solid waste facilities and screening thereof, well, maybe anticipated domestic water demand and specific amount of septic effluent. Those things, to my mind, fall into a different category from you didn't sign the W-9, okay? Or you didn't give me 3 out of 21. You know what I'm saying?
I do, and I appreciate your comment, and keep in mind that we have sort of two inquiries here. One is what is meant by the statute and what the burden on the applicant is in terms of being protected under Section 10.5, whether you need a complete application at all, which would kind of make these 12 items moot. But if you go to the next level of inquiry, where you're at right now, it's interesting. You could spend quite a bit of time on these 12 items. I can represent to the board, as another example, and many of these are similar, item 10 is actually my favorite. Item 10 says, site plan must indicate anticipated domestic water demand and amount of septic effluent. We submitted an engineering report, a 8.5 by 11 report, that had exactly that in it. Mr. Domenak's comment is that we didn't put that information on the plan. So, you know, hyper-technical, yeah, I think so. You can go through these items. I mean, you know, the contour, elevations, and topo are on the plan, but the datum or the measuring point wasn't there.
Counsel,
So-
do you have, I don't see anywhere in your submission, letters from you after July 15th submitting additional things to the township?
There were additional things submitted. We did not put them forth in the record.
Okay. Well, I mean, it might be relevant to the board to see what you actually did submit after July 15th, so they could determine whether or not it's has any meat to it. But you didn't put that in there.
If the board would like to see that, we can submit it. We took a different view of that. We, as you can see from our presentation, the main thrust of our presentation is that
You got enough in.
not so much that we got, well, you could put it that way, Mr. Bradshaw, but it's a little, I think it's a little, the shorthand is a little unfair, but I understand it's getting late and we're tired. I think a better way of putting that is going more towards Mr. Washburn's testimony, and that is the legislature did not intend by Section 10.5 to require a complete application. If they intended that, they could have drafted it very easily by adding one word, submission of a complete, emphasizing the word complete application for development. They could have put that word in, knowing there's another section of the statute that deals with completeness. So we presented the case based on the initial submission and Mr. Domenak's reply, and not sort of muddle the board with all of the back and forth afterwards. Mr. Domenak wrote me letters saying, hey, get me a couple more copies. We got him more copies. The fees change a little bit. We got him more fees. And if the board is of concern and that's relevant to the board, we can certainly supplement this record and, you know, make that submission. It's not, wouldn't it be difficult to do? We thought it was not quite relevant or germane to the issue, and would sort of just confuse things and lead us down a path we didn't need to go. But if that's the board's thinking, we're not adverse to submitting it.
And Laura, let me just say one more thing when we're talking about the completeness and the application for development. The things that we're talking about that may or may not be minor in nature, those go to that separate part of whether something is complete. Both boards have given me the ability to, whether it's grant a waiver or allow lesser amounts of things for completeness, to make a determination as to whether or not they think there's enough information to be made so the board can make a decision. But that's a totally different decision, which is what I'm
Okay, you
trying
know
to-
what, I think I finally understand the distinction.
There is, because when the application for development is vesting them the right that we can't change the ordinance, versus the completeness, which allows the board, in my opinion, and the board can require other information, where I make a determination that it is now ready to go before the board. There's a big distinction between the two of them.
Pat?
Yeah.
Do me a favor, tell me what it is that our ordinance in fact says. Because
You mean
I
the-
will tell you something, we've heard a lot of stuff, and I practiced municipal land use law for a number of years, and I agree with a lot of the stuff that the applicant has put forth. All of that having been said, bottom line, as a member of this board, I have to, I feel as though I have no authority to go beyond the scope of our ordinance. I want to know what the hell our ordinance says.
You're talking about the definition?
I'm talking about the definition, and that is the ordinance
Is it
that I feel like I'm bound
sorry.
by.
I-
We have it. I just want a legal
Oh, you want your
opinion as
counsel to interpret it for, oh,
as to
absolutely.
what is it that it says? Because there's a lot of language that is absolutely verbatim from the municipal land use law, and then it adds language from the municipal land use law relating to completeness into that definition of application for development. I'm not sure what it says and what it means, and I would like to know.
Well, I mean,
I know it speaks for itself.
it does speak for itself. I mean, I'm not the guy that interprets it, or utilizes it in the submittal process. I mean, that is the,
And Pat, I think that when I said in the beginning,
could read
to
it.
clarify it, is that our definition of an application for development, in my mind, is exactly, it mirrors the municipal land use law and just further clarifies what it says. It does not mix completeness, and I certainly, or let's say, I certainly don't interpret it that way, that it mixes. I think there's Mr. Washburn pointed out, I think we'll all agree, there's two separate paths that we're talking about. I use our definition as the same path as the municipal land use law. I do not use it as a completeness.
So what you're saying is that it requires the submission of all of those items, and if you determine that those items are satisfactory or complete, that's a separate issue. But at the outset, in order to have an application, you check off, these items, good, bad, or indifferent, must be submitted.
For instance, exactly right. You may submit a traffic report that for an application for development may meet the application for development. But for completeness, maybe it's 3 sentences, and it says there's going to be no additional traffic.
Okay.
So I may not allow that to be complete, but for
it-
for an application for development, it's met that definition.
And under those circumstances, would have, to quote Pat, kind of hit the goal line, right?
Yes,
Gone
because
over the goal line
there are
for this
instances-
purpose, okay, so.
Typically, I don't have to review them separately because we don't have this issue. So
Okay, so what you're saying essentially is that you have not gone through the completeness issue here. What you have determined is that certain submittal requirements have not been met, and therefore, under the definition of our ordinance, it's not deemed an application. Whether it is complete or not is for another day.
Well, I actually did go through the completeness during the process.
Yeah, but I'm talking about on July.
But as of
16th.
the effective date of the ordinance, there was not an application development as per our ordinance or as per the MLUL. Subsequent to that, at a later date, it's in my memo in October or whatever, they met both the definition of an application for development and they were deemed complete. So we could schedule them, which, the other thing, before we leave tonight, I had sent you an email prior about scheduling, if we're not going to schedule you within the 120 days, and we should put something on the record. If you want us to schedule you within that 120 days, we will. I don't want to get into a situation where we're at that time. So either if you want us to do, we can do that, and I can give you a letter in the next week or so. If you want to wait until whatever the next cause is, we would ask you for an extension until such time as you deem you want that. So I don't want to get into the statutory approval process, so.
Yeah, and-
You could talk about that.
We can talk about that later. I'd like to
Yeah.
confer with my client on that,
Yeah.
but we'll work through that with you.
So
Anything else?
where do we go from here?
Any other witnesses?
Did you want to say anything else?
No, I think we've talked this as far as we can talk it.
Council, you
Anybody
wanna
have
sum me?
anything else to say?
I have nothing further. That's our presentation.
And I say it's up to the board. Discussion, and motion.
The motion would be to, Council, you're right, it's not an interpretation, it's an appeal of the zoning officer's determination, so your motion would be to either affirm the zoning officer's determination or reverse it.
You know, my difficulty is with our ordinance, and I think, as I said at the outset, it's above my pay grade to make a legal or judicial determination. I came into this hearing with, having fairly carefully reviewed this with an opinion. There's a lot of stuff that you've given me food for thought, and I'm not as sure as I was when I walked in, but I think bottom line, while you've put in a good case, I think that the language of our ordinance, as at least I understand it, has to govern my thinking, and that I would deny your appeal.
Bob, are we ready for
Anybody else?
No. I mean, I'll be glad to move.
Well, does anybody else have any thoughts on this matter?
Yeah, my thoughts, and I think you clarified it at the end with the difference between the, as it was explained, the application for development and when it's deemed complete. Don't look at, the comment being made that of the 12 items, there are some that are probably on the surface insignificant, but if only the significant ones were listed, and then you filed again and you got another report back, these things still have to be satisfied, and you list the other ones, then we'd be accused of, as a township, of slowing down the process or impeding it. I don't see any reason that all the submittals can't be done according to ordinance when people are working on these things, obviously, for as much as 2 or 3 years in planning. And I don't think that we can go against the ordinance as another issue with it. So I would support the decision made by the zoning officer. Anyone else?
I'll have to concur with the chairman
I concur also.
at this point.
Is there a motion?
All right, I move that we sustain the zoning officer's determination.
Is there a second? All right, any further discussion? All board?
Mrs. Grauman,
Yes.
Mr. McCracken,
Yes.
Mr. Rich,
Yes.
Mr. Rosenthal,
Yes.
Mr. Reese,
Yes.
Chairman Thomas.
Yes.
Thank you
Okay.
for your time.
We have one
Thank
item.
you.
And that is the
Yeah, really quick, since I know it's very late and we've been here a while. As you know, our bylaws require that every year we go out for an RFP, a fair and open process for our board attorney. We did that. We received one. The process is twofold. First, you have to open it up to the public to see if anyone from the public has any comments on the bid. And then second, you have to do, as you always do, an interview. And then I guess there's a third part where if you do determine that you want to appoint the individual who's sitting next to you, that you would authorize staff to prepare the next necessary documentation for the January reorganization meeting, so he will be appointed.
Before you move forward, did you miss?
Yes, unfortunately, the most important page was inadvertently not put in. That's the page that indicates his rate, which is the same as it's been for the last several years.
Thank you.
And as far as opening to the public, but we'll make the comment that there
Is no public?
be no public.
So,
Is the application complete?
yeah, it was. Yes, our purchasing agent determined that he did
Complete.
submit everything that was required. So you just need to interview him, and then if you decide to authorize us to prepare the necessary documents.
Are there any important questions for anyone to ask Mr. Bradshaw?
So why do you want to be our attorney?
Because it gets me
Yeah,
home.
for nights like this.
Especially if it's
I've enjoyed working as your attorney for the years that I have, and I'd look forward to doing it again if you'll have me.
And in spite of tonight, the rate stays the same.
Yes, it does.
I move that we approve the rehiring.
Second.
Yeah, you're just authorizing us to give the documents, so in the January
Whatever it is.
or reorg, you'll actually appoint him, but we need
Okay.
that.
So all in favor?
Aye.
Opposed? Motion carried. And is there a motion to adjourn?
You got it.
So moved.